Good morning, Section Z. We're in Chapter 9 on the law of nuisance, and I wanted to do a very short discussion of nuisance and trespass. We've talked about in the last lecture how property law embodies elements from many of your other first-year courses, and so in respect to tort law, we saw, for instance, with personal property, there's the tort of conversion, or we briefly saw mention of trespass to chattels in the book. With respect to real property, there are a couple of torts that are significant that are designed to protect different interests in real property. And so the law of nuisance and the law of trespass, what's the difference between them? And the authors deal with this in the book. And so let me pull up that discussion and show you what they say about that. Here we go. So on the bottom of 478, they say, typically an intentional tort results in liability without regard to the amount of harm or the reasonableness of the activity causing it. Trespass involving a physical invasion of land is a case in point, while liability for unintentional trespass is virtually identical to that for unintentional nuisance. The two torts differ markedly if the element of intent is present. In such a case, trespass is treated like the other intentional torts. Nuisance, on the other hand, is usually subjected to inquiries about reasonableness and amount of harm. So, trespass is designed to protect your interest in exclusive possession of your property, whereas nuisance law is designed to protect your interest in the use and enjoyment of your property. Now, conceivably, you could have conduct that could be both a trespass and a nuisance. So for instance, they use the hypothetical of polluted water being released onto a neighbor's land. That could be a trespass because it physically invades the land. It also could be a nuisance because it impedes their use and enjoyment of the land. So the same conduct could conceivably be both a trespass and a nuisance. They also point out some marginal cases where it's hard to tell whether something should be counted as a physical invasion. So they talk about the fumes released from the aluminum plant, and arguably gases you would think of as not involving a physical invasion. You'd think of them as involving a nuisance-like activity, but they give you the Oregon case, I think it was, that analyze the release of fumes as a trespass, and on the theory that there actually is a physical invasion by very small particles. But there are also kind of cases where only one of the two torts would arguably be applicable. And so you could have things that are clearly trespasses but don't really interfere with your use and enjoyment of land. I could step onto my neighbor's property intentionally and step off in a way that caused no damage, in a way that my neighbor didn't even know about, and that would be a trespass, but it would not be an interference with the neighbor's use and enjoyment of the property, probably, at least certainly not a substantial interference. On the other hand, there's activity that could be a nuisance and would probably not be analyzed as a trespass. So for instance, if I am blaring loud noise from next door, it may interfere with my neighbor's use and enjoyment of their land, but it would be harder to characterize that as a physical invasion. But the question that the authors ask is whether it makes sense to treat intentional nuisance differently from intentional trespass, and to ask questions that are required to show liability in the nuisance case that we don't ask in the trespass case. Does it make sense that in nuisance we require a showing that intentional conduct creates a substantial interference with use and enjoyment of property? And does it make sense that we ask about the reasonableness of the conduct when it's nuisance, when we don't make those inquiries with respect to trespass law? And so here's the way the authors try and frame that question. Is there any sense to a system of rules that treats the intentional release of contaminated water onto neighboring land one way and the intentional release of polluting gases another? I wanted to highlight one point the authors make in the teacher's manual that they don't mention in the book, but that one common difference between trespass and nuisance is that in trespass cases, there are usually a much smaller number of parties. It may be, just one trespasser and one landowner, or a small number of people who are engaging in the trespass-related activity. And in nuisance cases, common nuisance actions might involve a much larger number of people. And so if I have the oil refinery, I may be affecting not just the plaintiff who has a house or a restaurant, but the trailer park and all of the other residences around and the church. Maybe a lot more people impacted by activity that is being analyzed as a nuisance. And so the author suggests that perhaps that helps explain why we analyze the torts differently. And they go back to the point that we made in our discussion of externalities, that one way to deal with externalities is through negotiations between the parties. And so if you're talking about a small number of parties in the trespass context, then arguably negotiations are fairly easy. And if you give the landowner a right to exclusive possession, they can bargain with the potential trespasser to make a decision about whether to allow the otherwise trespassory conduct and how much it's worth and that sort of thing. It's much harder for that bargaining to take place when you're talking about activity that creates a nuisance, because the transaction costs are much higher. Many more people who would have to be involved in the negotiations in order to reach a resolution. And so perhaps that's why the author suggests the courts have kind of tried to substitute for that bargaining by doing their own analysis of whether the conduct is creating a substantial harm and whether the conduct is reasonable or not. Now, notice down here on page 479, we talked about in the law of nuisance, the restatement had two different ways of analyzing whether conduct is reasonable. One, a balancing test where you weigh the gravity of the harm versus the utility of the conduct. And then the second one was a question about whether serious harm was being committed and whether it would be feasible to continue the activity and still provide compensation. And notice what they say, that Section 826B of the restatement, that second test, moves intentional nuisance in the doctrinal direction of intentional trespass, though there are still differences. And so one of the things it looks like the authors of their statement were trying to do is to kind of make intentional nuisance law a little bit more like intentional trespass by the way they analyze the reasonableness question. But think about that question for a moment that they raise. Do you see what doctrinal differences there still are, even if we apply that second restatement test? And let me just highlight a few of them for you that the authors mention, although not in your book. So that's why I wanted to highlight them. One is that intentional trespass still does not have the substantial injury requirement that intentional nuisance does. Secondly, an intentional trespasser is liable even if their conduct is reasonable and regardless of whether compensation is feasible. So those are distinctions from nuisance as analyzed under that second reasonableness test in the restatement. Third, they mention that trespass only protects possessory interests, and nuisance can protect non-possessory interests. And then they suggest that in some jurisdictions there might be two different statute of limitations for the two torts. But in any event, while the second restatement reasonableness inquiry for nuisance law makes nuisance law a little bit more like intentional trespass, there are still differences that they wanted you to recognize. And I'm going to stop there. We're going to do another lecture on remedies in nuisance actions in a little bit.